Morning, everybody. Welcome to the First District Court of Appeals. We have two cases to be argued today. When I call your case, if you could identify yourself and indicate your readiness to proceed. The first case is State of Ohio versus Flantoyle. Okay. Okay, thank you. And then the next case is Broomer versus Gilligan.
Good morning, Your Honors. Stephen M. on behalf of the appellant Matt Broomer.
Morning.
And Manny Burton on behalf of employees and cross appellants, also ready to proceed.
Okay, great, thank you. Mr. Cousins and Mr. Hoffman, if you all can come forward. Mr. Cousins, you may come forward. Would you like to reserve any time for rebuttal?
Yes, Your Honor. Just maybe 5 minutes.
5 minutes, okay. You may proceed when you're ready.
Thank you. Good morning, Your Honors. May it please the court. The issue before you today is whether the trial court, in dismissing a charge of resisting arrest before trial based on evidence presented in a motion to dismiss, is plain error. The state appealed.
So I guess I was a little confused on your invocation of plain error as a standard of review, because I didn't, like, to me, it doesn't look like this issue came up before the judge made a decision.
Your Honor, the state appealed under plain error as the state did not object to the court's decision to dismiss
Okay.
pursuant to Rule 48B, and therefore I think plain error was the only appropriate way to proceed from there.
Okay.
So plain error is an effect or defect which affects substantial rights which may be noticed, although they were not brought to the attention of the court, which this was not, as the state didn't object at the decision. The state has a substantial right to have a criminal trial conducted according to proper criminal procedure as established by the criminal rules and the Constitution of the state of Ohio and the United States. I think it's important to note other districts in Ohio have held that the Ohio rules of criminal procedure do not provide for a summary judgment decision on an indictment prior to trial, namely the 3rd District, 4th, 5th, and 6th District. And that's what the state is arguing here, is that the trial court effectively made a summary judgment decision.
And so let's assume that you're right. Given what the trial court has already held, what do you think is going to happen on a trial?
Well, Your Honor, we would plan to ask the judge to recuse as based on his findings of fact that he noted in his decision here. He's already made up his mind, the state feels.
Mm-hmm.
So that's what we would seek if this were remanded back to the trial court.
Okay.
So the operative words here that the court used explicitly that no woman in society, unless she had weapons on her, would have behaved the same way. This court cannot find her having met any of the elements under these facts of resisting arrest, and that she was not resisting arrest, but making every attempt to preserve her natural desire not to be exposed. This is effectively a summary judgment decision. He made a decision on the facts. There's one case the state cited to in its brief, the Nyheiser case, which was very analogous to the instant matter. Basically what happened there was the trial court conducted a hearing and dismissed the charges, and it found that the city official who had authorized the modifications, in this case cutting these trees down, that the cease and desist order was not given to the defendant until after the trees were felled, and that there was no evidence that the city had given authority of the subject park to a different city entity. So on appeal, the court held that the trial court had erred in looking beyond the face of the complaint to determine whether the motion to dismiss in that case had merit. The sufficiency of the state's evidence is a matter that should be determined at trial, and the trial court should not have.
And I guess, like, sorry to belabor this, I guess circling back to my prior question, you know, the more serious charges have been dismissed. And I'm just trying to understand, like, why is the city pursuing this appeal at this point, given the relatively inconsequential claim that's at issue? I mean, this isn't a case where she was assaulting police officers or anything like that. Like, at most, it may meet the technical definition of resisting, but, like, what's the state's interest in pursuing this at this point?
Well, Your Honor, this was, in my opinion, a bit more than the standard resisting arrest. Not to get too much into the fact, but there was a firearm there. Police responded. It was a very serious call that could have escalated and gotten much worse than it ended up being. That is why the state is deciding to proceed on this resisting arrest. But back to the Nyheiser case I was discussing. That court held that the sufficiency of the state's evidence was a matter to be determined at trial. Trial court should not have dismissed charges at that point. A review of the trial court's stated reasons for dismissal under Criminal Rule 48B in that case supported the finding that the issue went to an element of the charge. That is something that should have been determined at trial. So what happened here in this instant case, I think the proper course would have been for the court not to make these factual findings at this motion to dismiss, but at a Criminal Rule 29 motion at the end.
What were the other bases of the motion to dismiss?
The motion to dismiss, Your Honor, it was basically a motion in limine and a motion to dismiss kind of rolled into one. Basically, it was saying that if hearsay from 911 calls and the victim on the dismissed aggravated menacing charge, if evidence of his statements could not be introduced, then the state could not proceed on the resisting arrest charge, was basically the motion. In limine was to exclude any of these hearsay statements, and then if these hearsay statements are excluded, then the case should be dismissed, because the state.
And because of the posture based on the judge's decision, the judge didn't reach those issues. So again, if we agreed with you, wouldn't it need to go back for a decision on those matters?
Well, the motions were withdrawn. So I'm not sure what,
Okay.
Again, we would seek the court to recuse itself in this matter based on these decisions. It's already-
So you're asking for it to go back for a trial, and then at that stage, the defense could raise the motions again?
Yes.
Okay. And the judge had the video?
Yes.
I guess for the purposes of the motion hearing?
Yes, Your Honor.
And then he said he watched it and then made the determination that
Yes.
it wasn't resisting?
Yes, Your Honor.
Okay.
Yes. Your Honor, I guess I will just wrap this up by saying that I think it's quite clear here that the court explicitly made a factual determination and went as far as to say that the state cannot prove this because the elements of resisting arrest don't exist, that the actions of the defendant factually do not meet the elements. This is a summary judgment decision. Criminal rules state that courts cannot do that in these criminal cases. That's a civil issue. Therefore, I would respectfully ask the court to sustain the state's assignment of error and reverse and remand this cause. I'll
Thank you,
reserve
Mr.
the rest of my time.
Thank you. Mr. Hoffman?
Thank you, Your Honor. dismissal in this case was authorized under Criminal Rule 48B, and it didn't violate Criminal Rule 12C because it was not based upon insufficiency of the evidence. The trial court stated that the court was offended by the nature of the arrest, the circumstances around the arrest, and it did say that it felt that there was no resisting, but the impetus of the court's decision was based upon what it saw in the video about the.
Well, but I think like that's their whole point, is he's making a determination based on an assessment of the video footage, which, I mean, it's kind of like summary judgment, right? Like, are courts allowed to do that?
Well, I looked at 12C, and it's kind of open-ended, like 48 is. It says any issue can be brought before trial as long as you don't have a trial on the general issue.
Well, but I think that's the state's concern, is that ultimately the trial court stepped into the role of a fact finder or the jury and evaluated this evidence, found it lacking, and then ruled in favor of your client. I mean, that's I think what the state's arguing.
Right, and there's statements in the trial court's findings that support that, but there are also statements in the findings that indicate that it was offended by how this went down, by the.
Well, but again, is that a basis, like being
is.
offended
Yeah,
by?
yeah.
It is?
Yeah.
Like, what's the
To
rule?
dismiss a case, the trial court can dismiss a case for any reason in the interest of justice, as long as it makes findings in the record. And 48 requires findings of fact. It's not like you're not allowed to make findings of fact, it's required.
Can we review such a dismissal? If a judge just says, I'm offended, and then dismisses the case, how would an appellate court review that?
Well, under an abuse of discretion standard.
Okay.
I mean, it sounds funny, but I've cited cases where there were lots of considerations, like in the Bush case, the Supreme Court had 7 considerations to make, and they were considerations that had to do with the facts of the case, but.
So we would have to review, under your theory, if the judge abuses discretion by being offended by these charges?
Well, whether it's offensive, yeah, whether the police conduct in this case was offensive, yeah.
Well, it's not offensive. We wouldn't look at it whether it's offensive to us. We would look at whether the judge abused his discretion in finding it offensive.
Based upon the judge's explanations, yeah. I think
Okay.
so. The Elcado case is what I'm referring to, the 10th District, where there was going to be a retrial on a felonious assault case, and the judge dismissed before the retrial under 48B, and it
Well, let me
considered
ask you
7
that,
factors.
in that case, if it's a retrial, wouldn't the judge already be familiar with the facts?
Yeah, he would
Okay,
be.
But in this case, it was a pretrial dismissal.
Yeah, but there was an evidentiary hearing.
Okay.
Wait, why did the judge in Elcado dismiss it?
He did it because the state indicated that it wouldn't do anything new in the second trial. The jury indicated after the first trial that if they had a lesser included offense instruction, they would have found for that. There were no allegations of misconduct by jurors. The jury was split evenly, 6 to convict and 6 to acquit. The seriousness of the offense, policy issues, including judicial efficiency and economy, the fairness and burden that retrial would have on the appellee. That's what and it spelled it out, and the court held there was no abuse of discretion.
And in this case, the argument is that the judge dismissed because he was offended by the police conduct?
Right, because I have to go into the facts, but the
So if I'm a judge, if I'm a trial judge, and like, we agree with your position, and now I have this enhanced understanding of Rule 48, and I say, aha, I have a way to expedite my docket. I want you, state, to come in front of me, give me a proffer of the evidence you're gonna show, and if I like find it lacking, dismissing the indictment. And I'm just gonna go through and look at each case and say either dismissed or this is going to trial. Is there anything wrong with that?
Yeah, you're looking behind the curtain. I mean, you're doing something that would generally require a trial on the general issue under 12C.
Right.
So you can't do that.
Well, then, why couldn't I do that, but this judge could do what happened here?
Because the decision wasn't based upon, my position is, that it wasn't based upon the ultimate issue of whether there was resisting or not. It was based upon the reason for her behavior. And that's different.
Okay.
So if there are no further questions, I would ask that the court would affirm.
All right. Thank you. Mr. Cossins, rebuttal?
In response to Mr. Hoffman, I think the problem here is that the decision is obviously based on the ultimate issue of, is this resisting arrest? I mean, the court explicitly stated, the court cannot find her having met any elements of the elements under these facts of resisting arrest. The judge may have also stated that he was offended. He also stated that he thought the police caused her to be exposed, and that no woman in society would have behaved any differently. But bottom line, those are all decisions on if her actions do suffice to meet the elements of resisting arrest. I think that very clearly this is a decision on an ultimate issue. And based on that, Your Honors, I would just ask that you I would just ask that you
Yeah, I think you're asking us to reverse.
yeah, I misspoke, I'm sorry. I would ask you to reverse and sustain the state's assignment of error, reverse and remand.
All right. Thank you very much.
Thank you.
Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision. Hope you both have a great day. Okay, next case is Broomer versus Gilligan. And because this is a cross appeal, Ms. Burton, you'll also have the ability for, to reserve some time for rebuttal if you'd like. Mr. M? How much time would you like for rebuttal?
May I have 4 minutes, Your Honor?
You may.
Thank you. May it please the court, Stephen M. on behalf of Appellant Matthew Broomer. I think the first thing that we have to recognize as we consider this appeal is the undeniable fact that my client was not an employee at will. He was not an individual who could be discharged just cause or just for any reason or for any reason contrary to law. He was not an employee at will. He could only be lawfully terminated from his employment with the Appellees based on a legitimate business purpose. And the law is clear that the defendant cannot just claim that they had a legitimate business purpose to terminate this minority shareholder. It's not enough for them to say, we think we had cause. There actually has to be a legitimate business reason.
But so are you saying that their legitimate, what they claim is the legitimate business reason is pretextual?
Yes, well, first of all, I'm claiming it's false, right. No, it's not, I think I know where Your Honor is going. It's not a question of proving that they had an ulterior motive, as you would in a discrimination
Well,
case.
but I think that in a normal kind of closely held corporation squabble, and I was involved in a lot of those in practice, usually there's like a freeze out or some effort, like that's what the company is doing. They're making life miserable on the minority shareholder to extract some benefit from that. But here they like wrote him a check and paid for his equity. So I'm trying to understand like what is their nefarious purpose here in trying to get rid of him?
I don't think there has to be a nefarious purpose, Your Honor. I think what there has to be a legitimate business purpose to terminate him. In other words, there has to be a business reason why it's necessary that Matt Brummer doesn't work for the Gilligan Company anymore.
Okay, let me ask you this, Mr. Im. In your client's deposition, they said, okay, you're not doing this scheduling as we would like you to do it, and the company deems that to be important, but your client deemed it to be not important. So you're saying that the fact that your client didn't think it was important, that's not a legitimate business reason, while the company thought it was important?
No, absolutely not. We all of us who have been employees at one time or another may think that an employer's policy or particular decision is silly or not worthwhile, but we still do it. We still do it. And the situation that we have here is that, yeah, Mr. Brummer thought that maybe there was a little too much emphasis placed on this scheduling thing, but he was still willing to do it. And he told his supervisor, Ms. Beaver, when she was giving him his one and only write-up in 28 years of employment, he said, all right, I'll try to do better on these schedules. And so the fact that in the back of his mind he was thinking, I'm not really sure how much value this brings to the organization, is irrelevant. The question of the matter is, or the question for the court is, was there a legitimate business purpose to discharge this employee?
Wasn't there more to it, though? I mean, I thought that Ms. Beaver was keeping notes about his insubordination, and he was not, doing the things that she told him to do over a period of time. I mean, isn't that what got him fired?
I think there's a universe in which a jury could conclude that, Your Honor.
Okay.
But there's also a universe in which the jury can conclude that, no, absolutely not. That was not the reason for his termination. We're talking about an employee who had been there for 28 years, who had been getting good performance reviews right up to the end, who had no disciplinary history, and who is then presented with this one write-up, not a lengthy inquiridion of alleged insubordination or disrespect. He gets one write-up, and it mentions one thing, and that is, we really like to get your schedules in earlier. We'd like you to be more consistent with getting your weekly schedules in on time. It was the only thing that he was.
But I guess my question is, in this context where it's not a pretextual claim that there was race or sex discrimination or something like that, and I take it there's no contract that would say you must engage in some sort of progressive discipline, then like what's wrong with that? Whether it's the first time or the 100th time, if the company says this is our policy and you're not adhering to that, like what's wrong with that being a basis for termination?
The problem is it's not the law. That's what's wrong with it. It's not the law. If you have an at-will employee, yes, that's absolutely the law. We don't like the way your hair's cut today, you're gone. If you're an at-will employee, that's fine. But in this circumstance, he's not an at-will employee, Your Honor. He is as a minority shareholder, he has the right to share in the benefits of the corporation, and they cannot use their power as the minority shareholders to exclude him from employment. And that's the Thomas versus Fletcher case, that's Morrison versus Google, that's the...
So are you arguing that, so this is an undisputed fact that he didn't put his schedule in the way the supervisor wanted him to, though, right? That's undisputed.
It's undisputed that there were times when his submission of his schedule was delayed.
But you're
For
saying,
various reasons.
you're saying that the failure to do that does not rise to a legitimate business purpose
What I'm saying is that.
under the law.
Right, that's for the jury to determine. The jury needs to determine whether or not they had a legitimate business purpose to terminate his employment. Right. And it has to be a business purpose.
So,
In
so
other
could a judge never determine legitimate business purpose in a summary judgment?
If there were undisputed facts, as there have been in some of the cases that the courts have considered, if there are undisputed facts that an employee,
But I'm just saying, on the undisputed fact that he didn't put his schedule in as he was directed, that's an undisputed fact. He didn't do that, at least on one occasion, right? Can a
he
judge
was
then?
late on
can-
at least one occasion, right?
Okay, so that's an undisputed fact. Can the judge then determine whether it's a legitimate business purpose for summary judgment?
No, a judge could not make a determination. That issue has to go to the jury, because the law is that there has to be the activity of the employee that the employer is acting on has to actually disrupt the business in some fashion. The
Well,
Thomas versus-
wait, go back to that point. Where is the authority that says there has to be a business disruption? And it can't just be a business policy?
So in Thomas versus Fletcher would be the best example for that, Your Honor, from 2006, where the employer contended that the employee was being disruptive, or that he had been causing personality conflicts in the business, and the court said, look, the evidence was, in fact, the court in Thomas versus Fletcher granted summary judgment for the employee, finding that, look, the undisputed evidence is that the business was running well. Whatever personality issues were taking place between these employees, it wasn't preventing the business from operating. And that's exactly what we have here. The evidence
So
is-
just to make sure I understand, so your position would be that regardless of whatever policies the business may have, someone could violate those policies either a little or a lot, but that wouldn't rise to a level of a terminable offense unless it actually negatively impact business operations.
That's exactly right, Your Honor.
Okay.
That's exactly right. In the context of a majority and minority shareholder, a closely held business, that's right. The employer doesn't have the unfettered right to simply say, you know, I'm feeling tense about the way that you're behaving, or I don't like the fact that you didn't get your schedule in on time.
But there was testimony that did impede the ability for his supervisor to know what he was doing and, where to put other people. I mean, wasn't there testimony that this did in fact impact her ability to supervise her employees?
There was testimony, Your Honor, that she felt it was important that employees turn in their schedules on time. Absolutely.
Didn't she explain why, though?
Yes. And
Okay.
she explained why.
And the reason
And-
was what?
The reason was so that she could know where people were during the week and what
Okay.
they were doing there.
And then she said because he didn't do that, she didn't know where he was or what he was doing. So how is that not impacting the business?
Because my client was doing his best. Because my client, as other employees acknowledged, there were problems with the software. There were occasions in which it didn't work very well. My client testified very clearly that when Ms. Beaver came to him with this write-up on September 29th, he was receptive and said, I'm going to try to do better. I don't have a problem with this. Remembering that these two individuals had worked together for years and years and were friends. So, and that's where the issue, I think, really comes down to, Your Honor, is that there's a battle of credibility between the two sides in this case. We've got the defendants claiming that my client was slamming doors and shouting and giving ultimatums and all this sort of thing. My client says, look, Jen, called her Jen because they knew each other for a long time. I'll try to make sure that these schedules get in on time. It's not a problem. I'd ask you as a friend to discard this warning because I don't think it's warranted, given the software issues that everybody's had and so forth. So the jury's going to have to decide whether or not they're going to believe the defendant's witnesses or whether or not they're going to believe the appellant's side of the story. Because it
And
was just.
Mr. M, you're at your time now, if you want to reserve time for rebuttal.
Yes, I'm sorry. Thank you.
Okay, thank you. All right, Ms. Burton, would you like to reserve any time for rebuttal?
I'll reserve 3 minutes.
3 minutes, okay.
Good morning, Your Honors, and may it please the Court. Amanda Burton, on behalf of appellees and cross appellants, Pat Gilligan and Chris Zimmerman. Ohio courts have consistently emphasized the importance of enforcing release agreements that prevent, settle, and eliminate litigation, and they've touted their benefits. They save resources and time for the parties.
We understand those policy rationales. I think the issue with your release is it is limited, as I read it, to the transaction by which his equity was redeemed. And you all know how to draft a release that says every and all claims that you might have against the company are released. And I was looking for that language in the release and didn't see it. So it was essentially a release that was narrow to one specific transaction. And that transaction is not at issue in his claim. It's an employment claim.
If I may, Your Honor, I read the release a little bit differently, and let me tell you why. It's not limited to simply the sale of the ownership interest, and that's clear from the release. It says that Mr. Brummer agreed to release any and all claims that arise from or relate in any way to his ownership in the companies, his redeemed units. It does not say that it only bars claims that arise from or relate in any way to the sale of his ownership interest.
Well, but he's not making a claim related to his ownership interest. He's not saying, I got gypped on a distribution last year or something like that. He's saying you fired me wrong. So like if you had included employment in that release, like then it's a different story.
So 2 points in response, if I may, Your Honor. The first is the fact that it doesn't say termination agreement does not matter here. It doesn't need to say employment agreement or employment claims. It doesn't need to say that because the claims that we have here are claims that arise from and relate to his ownership interests. Mr. Brummer has brought 2 claims, but he's admitted you can call it wrongful discharge, you can call it breach of fiduciary duty, but it's essentially the same claim with a different name. And he went on to explain what that claim was. It was a breach of fiduciary duty claim that, of course, arises out of the fact Mr. Brummer was a minority shareholder. So the analysis should not be, is the claim specifically mentioned in the release? That's not required.
Well, but this gets
bar.
back, but I think this gets back to my question to Mr. M. Like in a prototypical like freeze-out scenario, the argument is you're firing me to prevent me from realizing some equity-based benefit or something like that. And that's not his claim. His claim is just simply, you fired me.
Right, but that's why his claim is not, it doesn't have merit. It's not why his claim isn't barred by the release. Without the minority ownership interest, Mr. Brummer would have no claim here. He would not have a breach of fiduciary duty claim because it arises from and relates to his ownership interest. And he would not have what he calls sometimes a wrongful termination or wrongful discharge claim because that claim too arises from or relates to his ownership interest.
Isn't this, you're asking us to do a broad interpretation of this contract, right? Aren't you asking us to broadly interpret the contract?
We believe that it should be broadly interpreted.
But isn't the
given-
law requiring strict interpretation of any kind of release, though? That's where I'm getting hung up, because I think you might be right under a broad interpretation of this contract. but if we strictly construe it, I don't know.
So Mr. Brummer does argue that the release needs to be strictly construed, but that confuses the standards. What the courts have said needs to be strictly construed are releases from future tort liability. That's much different than a release agreement like we have here, which is releasing past conduct. And so broadly worded releases like this one are generally construed to include all prior conduct between the parties, whether known or
Well,
unknown.
but see, I can't accept that because, like, if you want to release all conduct, then you say that in the release, and it's very broad and it's very clear. I mean, I mean, there's countless examples out there in the case law about, you know, and that's why we, you know, as lawyers, we put like 17 different adjectives in the release agreement to, if we want to make sure it covers everything.
But I would submit, Your Honor, that this release doesn't cover everything, but it does cover the claims here. Say, for example, Mr. Brummer had an age discrimination claim. That would not be covered by this release. We would submit that. There's nothing in the release that talks about that. But that's not the kind of claim he's brought here. He's brought two claims, both of which arise from and relate to his ownership interest.
Well, let me ask you this, ma'am, because just assume that he has a legitimate claim, and by signing this agreement, he's giving up that legitimate claim, right? I mean, that's your argument.
Exactly.
Right? So his alternative is don't sign the release and don't get your $500,000 and go to court, right? Is that where it is?
That's exactly right, Your Honor.
But then he would still be entitled, I assume, to his $500,000 at some point, right?
That's right, but
So he's
he-
giving up his claim by signing this.
Exactly. He accepted over $500,000, and one of those terms in that agreement was the release.
Okay. But had he not, you wouldn't be able to make this argument had he refused to sign the release, despite the fact it says he has to sell his shares back upon termination.
Correct, Your
So he would
Honor.
be in breach of that.
It's the release he agreed to that bars his claims. That's exactly right.
But going back to what you said about this broad interpretation, because apparently now you're telling me that the strict construction is only for release of future tort claims. But in this situation, we can do a broad construction of the release language. What is your best case that supports that?
Yes, Your Honor. So, sorry, I don't want to misspeak. But we believe that the release has to be, well, there's a couple of cases. I'm sorry. Yes, and so Owens versus Bridgestone, which is a 10th District case, 2020 Ohio 5156. We cite in our brief the Crutcher case, 2022 Ohio 4105. And so we would point the court there. There's been some confusion, I think, on the standard about just using the term release. We're not talking about here a ticket that you purchase before you bungee jump, and there's a release of future tort liability. What we're talking about here is a release akin to a settlement agreement where the parties knowingly entered into it with the help and advice of counsel. There was exchange of over $500,000, and one of those terms is a release that does not release all claims. It does not, but it does release these because they both arise from and relate in any way to his ownership interest.
If you read it broadly.
Correct.
Right.
Well, one more point. Honestly, even if you read it strictly, right? Because in what way could any of his claims exist without the ownership interest? So even if you construe the release strictly, as narrowly as it's written, which in fact the trial court did, everybody agreed that the release bars any all claims that arise from or relate in any way to his ownership interest, because that's exactly what the language says. So I would submit either way you construe it, here the release bars the claim. For all of those reasons, we also believe that the counterclaim should be reinstated and that the court should remand on that basis. But I do want to really quick address the legitimate business purpose.
Just real quick before you do that, so you are arguing that this release is not ambiguous, right?
So we have reserved that argument, Your Honor, but we don't think that you need to get there. We have said if there is any question about ambiguity, that the court should not have made that determination in its own instance, and instead, those questions should be presented to the jury.
Okay.
So, but even setting aside the release, Mr. Brummer's claims still fail. If Mr. Brummer's termination was initiated in good faith and for a legitimate business purpose, he has no claim, and that's the case here. There is no dispute that Mr. Gilligan and Mr. Zimmerman terminated Mr. Brummer because his supervisor, Ms. Beaver, reported to them the ongoing issues she was having with Mr. Brummer and his insubordination, and the impact that was having on her ability to run the business as director of operations.
And what about Mr. M's point that in order to terminate someone in this circumstance, there has to be some I forget the word, but interference with the business operations? I assume you all disagree with that.
So 2 points in response, Your Honor. One, there's no case that supports that proposition, and certainly Thomas v. Fletcher doesn't. If you read that case, what it says is there were no facts in support of what they were alleging was the legitimate business purpose there. That there was simply a failure of proof. That's certainly not the case here. But even if there was a requirement for it to impact the overall business, that's happened here. Because Mr. Brummer's insubordination and his misconduct were undermining and disrupting Ms. Beaver's ability to do her job and to run her team. That's undisputed testimony in the record. And so even if the court believes that we do have to show some overall disruption of the business, that was shown here. Certainly the impact that, that there's some impact on the company's bottom line as a requirement is not supported by any of the case law here. Gilligan did not have to wait for Mr. Brummer's insubordination and misconduct to do so much damage that it was affecting its bottom line. So that is not supported by the case law, and simply just a meritless argument.
And you are at your time if you want to reserve 3 minutes.
Thank you.
All right, thank you. Mr. M., you have 4 minutes.
Thank you, Your Honor. I think, first of all, it's important to keep in mind that we are here on appeal of a grant of summary judgment. And so, of course, the standard of review is de novo, and furthermore, the evidence in the record is not construed in favor of my colleague's client. The evidence in the record has to be strictly construed in favor of Mr. Brummer. And the evidence is conflicting. And the evidence is conflicting as to why my client was terminated. The evidence is conflicting as to whether or not he gave any cause for the termination. The evidence is conflicting as to whether or not there was any legitimate business purpose to terminate my client. And my colleague likes to say that the evidence is undisputed that the business was disrupted. It's not. It's not. My client worked for this company for 28 years, got positive performance reviews up to the very end from 3 different managers, and had 0 disciplinary history whatsoever until September 29, 2 days prior to his termination. And that single discipline that he received was about one item, and that is these weekly schedules that she felt she wasn't getting fast enough. And my client's testimony about that was, he said to her, "Look, Jen, that's fine. I'll try to do better. Please disregard the warning. We've known each other a long time." That was it. And then 2 days later, he's fired. 2 days later, nothing happened in the interim. He did not do anything else after that. He wasn't even working after that. They decided to suspend him and then terminate him because they didn't like the fact that he refused to sign a warning. Well, he didn't agree with the warning. He didn't think it was justified or warranted. Is that a legitimate business purpose? Or
Well, I mean, I think that's part of the issue. Like, it's not up to us to, like, micromanage what policies an employer implements. I mean, if the employer said, for instance, everyone has to wear a blue shirt every day, and your client said, that's stupid, I'm gonna wear a white shirt or a beige shirt or something, and did that for several days, like, under your theory, in this situation, could they be fired for that? Even though we all think that that's silly.
Absolutely, Your Honor, because in that event, you're talking about an employee who is deliberately defying on a repeated basis an employer's instruction. That's not what this is. We've got a situation where Ms. Beaver says, I want you to do a better job on your schedules, and my client says, okay, but I'm just not gonna sign this warning, because I don't think it's fair. Now, employers do this all the time. They say, okay, refuse to sign, they put it in this file, and they move on. If the employee violates again, then of course that can be subject to further discipline.
Is there really a genuine issue of material fact on why he was fired? Or is the genuine issue of material fact on whether this was a legitimate business purpose?
I think it's both, Your Honor. I think it's both.
Because, I mean, it
think
seems pretty
because-
clear why he was fired.
I agree with you. I think it's clear. The defendant felt otherwise, but I believe it is clear. I believe he was fired because they issued his warning. He said, I don't want to sign that. I don't think it's right. And that's 2 days later, he's fired. I think that's the reason, the
Okay.
stuff that they came up with.
Okay, but if that's the reason, then isn't the real issue whether it's a legitimate business purpose and impacted the business in some way?
Yes, exactly. And I think that is the issue. And I think that's an issue that has to be construed in favor of Mr. Brummer on summary judgment. I think that it's an issue that ultimately has to decide. Now, the jury may ultimately decide, yeah, I think you're refusing to sign this warning, Mr. Brummer, gave them a legitimate business purpose to fire you. But a reasonable jury could certainly find otherwise, could certainly find that, wait a minute, no, you're talking about somebody who's done a good job for this company for a very long time. He's got one single disciplinary action. The company hasn't been sued because of anything he's done. The company hasn't lost any customers or any income or any vendors or any employees because of anything he's
Mr. M,
done.
you're at your time now.
Very well. Thank you, Your Honor.
Ms. Spartan, you have 3 minutes.
I just want to briefly address the legitimate business purpose a little bit more. Mr. Brummer has not argued or alleged, let alone pointed to evidence that would suggest there was any other reason motivating the termination decision here. And certainly no improper or nefarious reason that would support a breach of fiduciary duty hearing. The focus must be on Mr. Gilligan and Mr. Zimmerman and whether their actions breached any fiduciary duty they owed. Because they did not, the trial court properly granted summary judgment. This is the sort of case that the Second District had in mind in GJAX when it cautioned courts about the importance of properly balancing the need to protect the minority shareholder employee with the needs of the close corporation in ridding itself of an unproductive or troublesome employee. That's exactly what Mr. Gilligan and Mr. Zimmerman were doing when they decided to terminate Mr. Brummer. His supervisor had reported that he refused to follow her orders and directions, and that it was undermining her ability to run the business. As my friend on the other side said, deliberately defying a supervisor's order, that sounds like a legitimate business purpose, and that's exactly what the case was here. There were numerous examples, and they're undisputed. He did not enter his schedule. Contrary to what you heard earlier, this is not disputed. Mr. Brummer admitted that in his deposition, and he wasn't shy about why either.
So
He
let me
didn't
ask
think
you
it was
this, like,
important.
from your perspective, I think both of you are taking a little bit of extreme positions, but I understand them. But from your position, if the company says, this is our legitimate business purpose, we have a policy, whatever, can that be questioned? Like, can there ever be summary judgment denied for the employee?
it could be questioned if there was some suggestion that that was not done in good faith. So those are the two prongs that give rise
So
to
he
this.
says the lack of good faith is exhibited by, jumping to termination before other measures and, going so quickly here. So like, how do you respond to that?
And the record simply doesn't support that, Your Honor. Take the schedule example on its own. He was told in January of 2021 by his supervisor, and by his supervisor, which is Mr. Zimmerman, that putting in his schedule was important and explained why. 9 months later, after multiple violations of putting in his schedule, he was issued a written reprimand. And he didn't want to sign it. He told us why. Not because anything in there was untrue, because he still didn't think the schedule was important. It's a clear case of insubordination. Gilligan did not need to put up with its employee refusing to do even the most simple of tasks, deliberately defying a supervisor's order any further.
Okay, you're at your time.
Thank you, Your Honor.
Thank you both for your arguments today. We'll take the matter under submission and get out a timely written decision. Hope you both have a great day.
Court of Appeals, First Public District of Ohio is now adjourned.